Right, I think we'll make a start. My name's Anna Datta. I'm a barrister at Parklane, Plowden Chambers, and I specialise in clinical negligence and also call to protection cases. Obviously, this is law with lunch, and I appreciate that you're probably all munching on your sandwiches right now. So I'm going to try and keep this light and breezy, and it'll be a whistle-stop tour through how to deal with capacity cases that may arise in your practice. Hopefully will be about 30 to 40 minutes. At the end of the session, what I'll do is I'll open the question and answer room. And if you have any questions, then feel free to type them in then, and we can deal with them at the end. So starting off, you have a client that comes in to see you in your practice, and the first question is, well, where do you start if you think that there may be a capacity issue? And what I wanted to deal with is that in the first 3 bullet points that I've got in this slide are really kind of the 3 golden rules that I would say that you need to bear in mind with any type of capacity case. So the starting point is that there is always a presumption of capacity, and often it's a mistake that we see made where that's turned on its head, and that effectively somebody has to prove that they have capacity. That's actually the wrong way round that we need to be looking at it. There's a presumption of capacity which needs to be rebutted. So your starting point should always be that the person in front of you is capacitous, and then you need to gather any evidence that you may have to demonstrate that they are not. The second issue is that capacity is decision specific. So, for example, you may have a client that has capacity to manage their finances because they are relatively of modest means, and the money that they're dealing with is relatively small, and as a consequence they can cope with that quite well. But obviously in a clinical negligence case there is likely to be complex medical evidence. There is going to be discussions about legal concepts such as causation, and those are quite tricky. And as a consequence, you can have a client that has capacity in one area of their life, but not necessarily have litigation capacity. And so it's always very important that when you're looking at something, you are looking at each and every decision that is going to be made. And we don't assume that because somebody has a diagnosis, for example, that they may lack capacity, or because you have a client, for example, wife or husband who says, well, they don't have capacity because they don't have capacity in another area of their life. The important thing to do is to always think about the decision that you're getting somebody to make. So usually in our context, it's the capacity to litigate and to make decisions with regards to the litigation. But obviously capacity can be dealt with in any number of areas in the duration of a case. And it's important that you take each of those individual decisions on their own merits. And that may mean that you need capacity evidence to deal with several aspects. For example, in the call to protection, it's not unusual that we may have 5 or 6 different capacity assessments to deal with different individual decisions which that person may need to make. The third point is that capacity is time specific. And that's because capacity can fluctuate over time. If we think about somebody who may have mental health issues, they may, when their mental health issues are particularly prominent, not have capacity at that particular time. But once they receive treatment, they may regain capacity. And then again, if their condition is poorly controlled, they may also lose capacity again at a later date. And so you can see how over the course of proceedings, especially in stressful proceedings and potentially when you're getting closer to court, you may have to reassess capacity with certain individuals. The other example I would give is, for example, you have a relatively elderly person. When you first meet them, they may have capacity. They may then lose capacity because they, for example, develop dementia or another medical health condition over the duration of the case. And at that point, capacity may need to be reevaluated. So it's important to have in the back of your mind that just because you have done a capacity assessment at the start of the case, it doesn't necessarily follow that the capacity assessment won't need to be reevaluated. So it's important to make sure that you're keeping that particular issue under review for the duration of the case. The third bullet point I've put really because it's a point which comes up, I see it regularly in the Quarter Protection, and it's just really a useful reminder, because capacity can feel very much like it's a medical test, especially bearing in mind that we rely upon medical experts potentially to give evidence on it. But it's important to bear in mind that it's actually a legal test. So, for example, the medical evidence may assist the court, and it may be an exceptionally good starting point. And clearly, medics are used to dealing with capacity decisions on a regular basis, and therefore they may be best placed to make that assessment. But ultimately, the decision of whether somebody has capacity rests with the judge, and it's a legal point. So that's something to just bear in mind when you're looking at capacity evidence. So the starting point has to obviously be the Mental Capacity Act, in particular Section 2.1. And you can see that the definition of capacity is relatively neat and short. But how it's actually applied in practice is a little bit more nuanced. And so on the next slide, that's what I'm going to be dealing with. The key case at the moment is a local authority in JB, which is a recent Supreme Court decision. And that was an interesting case because prior to this case, what used to happen is the starting point would be that you would deal with someone's diagnosis and condition. So, for example, dementia or schizophrenia. And then you would almost box tick that and move straight onto the second limb of the test. And what the Supreme Court said is that's the wrong way round to look at it, and that your starting point should be to deal with the actual decision that is being made. And the reasons they said for that was that if we do it the other way round, rather like what was happening, there is almost an assumption that because somebody has a disturbance of the mind or a mental health condition or a diagnosis, that was causing the lack of capacity. And what the Supreme Court said is, well, that's not necessarily true. And it's always important to make sure that you have that causal link between the two things. And so as a consequence, if you do it the other way around, it forces you to really look at that decision, force how you're going to support that person to make that decision, and then to consider the link between the diagnosis. So when we're looking at these, in my opinion, there are kind of three questions that we need to deal with. In a local authority in JB, they merged it into two, but I think it's helpful to look at it in three ways in those three questions that I've got on the slide. So the starting point is whether that person is able to make a decision. And when we're looking at whether somebody can make a decision, you're really looking at three areas. So first of all, can they understand the information that's being given to them? Secondly, can they retain that information long enough in order to be able to make a decision? And it doesn't really matter if they can't retain it long term or even for a relatively short period of time, as long as they can keep it for the duration that they need to be able to make the decision. And thirdly, whether they can use up and weigh that information. Now, in most borderline cases of capacity, it's usually the final area which causes the most concern, so the weighing up of information. And that's a difficult area to prove. And you really do need to make sure that your medical expert has sufficiently explained that area, because obviously it's a judgment call whether they've been able to weigh up that information. And so you need to be able to demonstrate from the capacity assessment how you've been able to come to that conclusion. The second question is whether there's an impairment or disturbance of the function of the mind of the brain. So usually their diagnosis. And then thirdly, whether, as we talked about before, establishing that causal link between the two things, because obviously somebody can have a diagnosis, but that may not be what's causing them to be unable to make the decision. There may be something entirely different. So that's the test that needs to be applied. I guess I want to look at more kind of a pragmatic approach now, because that's the legal basis, but realistically in practice, how do we deal with that? So looking at the assessment of capacity, the first question is, well, what evidence do I need to prove it? Because as I said at the start, the burden is on you, or not the solicitor, but the person asserting that somebody lacks capacity. So think about the type of evidence that you may need, and the veracity of that evidence is really going to depend on how borderline it is. So as with all clinical negligence cases or personal injury cases, we keep an eye on proportionality. Clearly, if you've got somebody who's got very established dementia, they're receiving care, they don't have capacity in any other area of their life, it's unlikely that they're going to it's unlikely that they're going to have capacity to litigate. And in which case, the evidence that you need to present to the court will probably be quite straightforward, and it's not likely to be challenged. And in those circumstances, a letter from the GP referencing when the diagnosis was made, referencing that an assessment has been done on X, Y, and Z occasions, and the difficulties that it has caused for the claimant is probably going to be sufficient. And it's probably not going to be challenged either. If, however, you've got a fairly more nuanced case, then obviously you're going to need potentially some more detailed expert evidence, and expert evidence which is specific to that claimant, specific to these proceedings. So, for example, a medical report from a neurologist or a psychiatrist would be entirely appropriate, and is often seen in cases where it is more difficult. It's also worth bearing in mind, though, that because it's not a medical test, you can also have other individuals potentially give capacity evidence, such as a social worker. And in the court of protection, quite frequently, we do have assessments done by a social worker, and the social working team may be able to provide you with capacity assessments that they have done on the claimant in other areas of their life. There may, for example, already be a capacity assessment that has been undertaken if there are court protection proceedings. So it's worthwhile always considering that point as well. So what I wanted to do is look at three kind of pitfall areas that I think come up when we're looking at capacity assessments. And the first of these is the issue of language in capacity assessments. So language is critical, and it's important that when you look at a capacity assessment as a solicitor, if capacity is going to be a contentious issue, that we make sure that our capacity evidence really is on point. And the language really is the starting point, and usually a point that is easily flagged up and changed relatively quickly. And the language is something that I find in court when I'm looking at court protection proceedings, that language is frequently got wrong. So, for example, we quite often see language in assessments such as the patient has failed to prove, or the patient is unable to demonstrate. And as we've already established, it's the wrong way round to be dealing with it. And a good case and a recent case is the case of SS and LB Richmond upon Thames, which is a court of protection case which dealt with COVID-19 vaccinations and the capacity to make a decision in relation to them. And in this particular case, the capacity assessment was relatively brief. I believe the lady had dementia, and that the GP dealt with had a good working relationship with the individual, and the GP conducted the capacity assessment. And when they did, the documentation said the patient failed the capacity assessment. So this was before the Court of Protection, in particular Justice Hayden, on another issue. But as a matter of comment, Justice Hayden gives a helpful guide as to what we should be looking at. And I think he really describes in a nutshell the problem with language. So I'll just quote to you a small passage from the judgment. Justice Hayden says, "I hope Dr. N will not think me being too pedantic if I make the observation that the patient failed the capacity assessment strikes me as awkwardly expressed. It is not a test that an individual passes or fails. It is an evaluation of whether the presumption of capacity has been rebutted, and if so, for what reason." Now, I think the reason why I've put this case in is because it's a useful reminder as to the language that we need to be using in the capacity assessment. But was also important was that Justice Hayden didn't find that the kind of slightly sloppy language was fatal to the capacity assessment. So I'm not suggesting that if your doctor or social worker or whoever is doing the capacity assessment is slightly sloppy in their language, then that means that it's essentially game over. It's not. But what I do think is that when you have those borderline capacity cases, if you have two experts and one expert is able to succinctly and demonstrate that they understand the test, and the other, through sloppy language, has demonstrated potentially a lack of understanding of the test, clearly that's going to undermine the credibility of the expert. So it's something that if you do see, I think is worth flagging up with your expert and getting them to change it. So the second point is really the process that somebody has gone through when they're undertaken the capacity assessment. And again, that should be evident from the capacity assessment that you have before you. So it's important to always bear in mind that a capacity assessment shouldn't be a memory test. And as Justice Hayden said, it shouldn't really be a test at all. And it's important that steps are taken to help the claimant or the patient before concluding that they lack capacity. And I think this is worthwhile bearing in mind when you're looking at capacity assessments, but potentially when you meet the claimant for the first time and you are undertaking, those initial interactions with the claimant, to help yourself to know whether there might be a potential capacity issue. So steps that may be taken, for example, in a clinical negligence case, would be making sure that any advice that you are giving is backed up in writing. So obviously these are things that you probably do anyway with any claimant, but even more so when you have an issue of capacity. It just means that they were able to obviously take it away, consider that information in their own time, and that helps with the retaining of the information for them to be able to make a decision. Making sure that any advice is clearly laid out, using visual aids if that would assist. It's difficult potentially in a clinical negligence case, but obviously if you've got accommodation issues, that type of thing, showing them the accommodation would definitely assist. I think this is an important one, especially for that initial meeting, is making sure that the claimant is settled. So, for example, if you do think that there may be a capacity issue, potentially seeing the claimant for the very first time in their home setting may settle them more and may give you a better guide. It also making sure that they have somebody with them who they trust. So, for example, a partner or a family member or even a friend. And making sure that you give them that information at kind of a reasonable pace. And that might mean that you see them over several occasions, or, for example, as we've already said, you give them the information to take away to consider at a later date. With regards to an actual capacity assessment that's been done by a professional, a useful case is PH&A, where the court really stressed that there may be an important, especially in borderline cases, of conducting that capacity assessment over a number of visits. And they caution against simply seeing like a snapshot of that individual, because obviously you may see that individual on a bad day, or you may see them on a good day, and that's not necessarily reflected. And we certainly find that in the court of protection, that when we have cases where it's very much borderline, sometimes it takes a couple of sessions to get to know a claimant, to kind of understand the way they're thinking. And sometimes you find that claimants are quite good at masking the lack of capacity. So they seem to be able to talk the talk, but it's only once you meet them on several occasions and you dig down that you realise that actually that might not be that might not be true. It's also important, I think, to look at the process of the assessment. And so this is really about kind of a documenting and evidencing an opinion, something that you would expect a medical expert to be doing in any event. But I think in capacity evidence, it's quite easy to skim over things. So realistically, you want to make sure that the assessor has documented everything. Say, for example, what was the environment like when they were talking to them? Were they in the home? Were they in a care home? Were they in a clinical setting? Were they settled? Who was with them? What information was given to the claimant? Was any written information given? Certainly if there's been anything to assist, such as visual aids, that type of thing, that's important to make sure it's documented. It's important to look at what was discussed. So what you really want in any capacity assessment is almost a transcript of what was discussed with the claimant. So you want not only the questions that have been asked and the information that's been given, because that's critical for demonstrating what information the claimant's been able to retain, but also their response. And that can be responses even if they don't seem to have any relation to the evidence, because if you've got a claimant that gives you responses which have nothing to do with what you've just asked, then that's a good demonstration, obviously, that that person doesn't have capacity because they're unable to retain the information and to weigh it up. And then finally, and I think this is a bit that is often skipped when looking at assessments, what information could, justifying really why that expert's come to that decision. So really a good explanation as to why they felt they weren't able to retain the information. What did they say that made them think that? And more importantly, when we're looking at weighing up, and that being a subjective element, why they don't feel they're able to weigh up. So for example, did they give too much emphasis on one point? Did they fail to even take into consideration a point that most people would consider to be very important? Or did they completely go off on a tangent? All of those are really important to mark down. Now, the case I've cited there of Martin and Salford was actually a clinical negligence case, but it has a useful, and if you want to consider capacity in a clinical negligence context, I'd urge you to go and have a look at it, because it does give a good basic breakdown of how you should be dealing with capacity. And the issue in that particular case was whether the claimant had capacity to manage and control the money that was going to be awarded by the court, and therefore whether there could be a recoverability of court of protection and deputy fees. The claimant had a long mental health history. There was diagnosis of emotional unstable personality disorder, but also from schizophrenia. And in fact, the claimant had been sectioned on a number of occasions. And both sides there were two experts in the case, both of which had done various assessments on the claimant. One had just relied upon a psychometric testing in a fairly clinical setting. The other had taken a less clinical setting, which turned out to be quite important, because what the judge said is that the setting that the patient was in was crucial, and that he preferred the evidence of the expert who had seen the patient in more of a real world setting, because that was a better indication as to how they would present in real life. Also, it's a useful case because it's a reminder that we don't necessarily have to rely upon just the medical expert's view, because what the judge did in this case was apply considerable weight to the oral evidence that had been given by the claimant's father, that he had been asked by the claimant how she should manage a sum of whether she should lend the sum of £10,000 to somebody. And the judge found that the fact that the claimant had sought out help demonstrated a number of things. Firstly, that she had retained the information long enough to be able to seek help. Second of all, that she had an insight into her vulnerabilities and the fact that she needed help. And thirdly, the fact that she'd been able to solicit and then act upon that advice showed that she was able to weigh up things in order to be able to make a decision. And so as a consequence of that, the judge found that in respect of the decision to manage her finances, the claimant did have capacity, and therefore she couldn't recover the court of protection and deputy costs. It's also, and you'll see from the third bullet point, I think important that the expert notes what records they've seen, and it may be appropriate for them to look at the medical and social care records and also the witness statements, and if so, that needs to be documented as it may form part of their decision. So if you've assessed your claimant and you've come to the conclusion that they don't have capacity, where do you go from there? Well, the first starting point is obviously that they're a protected party under the CPR, and therefore they're going to need a litigation friend. And obviously that can be a family member, or it can be a friend, or you may in fact need a professional litigation friend in some circumstances. It's interesting to note, though, that in civil procedure rules, there's actually no requirement to demonstrate evidence that the claimant lacks capacity. It's important now, I think, and I think realistically, it would be certainly wise to make sure that you do have some evidence of some sort. So, for example, if you have the certificate of suitability, make sure that addresses the test under the Mental Capacity Act. If you do have any evidence, and make sure that that is also filed at the same time, because that's certainly going to be important. And as I said at the start, obviously the type of evidence that you file is going to be reflected from a proportionality point of view as to how clear-cut it is going to be. And that you may just need a GP's note as opposed to a full assessment. Now, the biggest, I think, pitfall that is easy to fall into is really limitation. So this is a good reason, in my opinion, why limitation needs to be considered very early on in the case as really a requirement. And it's important to assume that just because the person that you see in front of you doesn't have capacity at that point, that doesn't mean that they didn't have capacity at the time of the negligence, and in which case that will then affect limitation. And the reason for that is because of this exceptionally old case, a case I don't think I've ever quoted a case quite as old as 1661, but it's important to note that it's still good law. And basically that's once limitation starts to run, it can't be stopped. So if you have a claimant that had capacity, say, for example, at the point of negligence, limitation is going to run from that point. And even if they then subsequently lack capacity later, it doesn't stop. And there's usually an assumption that because of there's being a limitation extension into Section 28 of the Limitation Act, that if you have somebody that doesn't have capacity, then you're fine. But you're certainly not. And it's important that you consider that at an early stage. And it's also important that it doesn't matter how brief a period of capacity they had. The point is that if they did, then limitation starts to run. You may be aware of the case of Adamonu and Colvin. There was a law with lunch up on it last year with both myself and a former member of Chambers, Gemma Lieberman. That's still available, I think, on the website if you wanted to go back and have a look at it. But in this particular case, limitation was heard as a preliminary issue. And it was a clinical negligence claim where the negligence had occurred in 2010, but the case itself hadn't actually been brought until 2017. The solicitor in that case seems to have incorrectly assumed that the claimant lacked capacity, and therefore the 3-year limitation period didn't apply, hence the reason why the case had been brought in 2017. But there was quite a lot of evidence in this particular case, and what happened is the judge found that the claimant did have capacity to conduct litigation, and always had done, in fact, but recognised that the claimant did need quite a lot of help and assistance in order to make those decisions. And as a consequence, the judge found that the claimant had constructive knowledge back in 2010, and therefore the claim was clearly out of time. Interestingly, and for reasons that are beyond this particular talk, Section 33 was also applied, and therefore limitation was extended, and the case, I think, it then went on to proceed. But it's a really good case and a cautionary tale as to the pitfalls that you can have if you don't identify capacity at an early stage. So again, from a procedural and a practical point of view, capacity can make a big difference as to the cost budget. In my experience, if you've got somebody who lacks capacity, it tends to be more costly and time consuming to prepare the case. And obviously you'll want that reflected in your cost budget. You're likely to need greater medical evidence, if not because you need a capacity assessment and therefore an additional expert. You're likely to need a litigation friend, which is going to take time to appoint. But that also means that there may be longer corresponding with the litigation friend, which takes time to obtain obstructions. If everything needs to be put in writing and clearly set out, that may take you longer as well. Basically, the essence is make sure it's reflected, because if it's not, then you're not going to recover it. But it is a good reason why something is going to take you longer. So it's a good way of getting extra costs if you need them. Evidence. Now, this is an interesting point, because you would have thought that if you don't have someone who lacks capacity, it wouldn't necessarily make cause an evidential problem. But in my experience, it can do. And the reason for that is because you're essentially relying upon getting your evidence to support your case from the claimant's perspective, usually from a third party, so from a family member who may not live with the claimant. And a good example, I think, is, for example, we have an elderly claimant who's living in a care home who has pressure sores, and that's the negligence relates to the pressure sores. Now, clearly, if the claimant doesn't have capacity, they're unable to tell you potentially about the pain and suffering and any loss of amenity that they might have. So you're really going to be reliant upon the medical records and family members potentially visiting. And so you can see how that may then cause an evidential problem when you're looking at quantum, for example. And so it's important to consider that, make sure you really cover your bases with the additional witness statements that you may have, but also to bear in mind that that might affect your litigation risk proceeding to trial, because you're not going to have somebody to really amplify, they're not going to be able to sing, to really promote their own case. And so that's something to keep under consideration if you've got any offers, for example, that you may want to consider. So settlement, as we've already touched upon, so I won't labour the point, in Martin and Salford, obviously that was a good case to remind us that we have to be cautious and show that there's an evidential basis for claiming things like court protection and professional deputyship costs. In essence, all I would say is simply don't assume that you could get them as a matter of course. Finally, under CPR 2110, any settlement is going to need approval. That may help with pushing for a more generous settlement if you've got talking about offers, or if you're at a JSM, for example. But also it's worth bearing in mind that any advice that you do in relation to that is going to need to deal with the litigation risk aspects, because the judge is going to want to fully understand what the litigation risk was and the reasons why an offer, for example, is acceptable. So make sure that when you're instructing counsel or to do an advice, that it covers both the merits of the case and also quantum. So in summary, the golden rules are essentially always consider capacity in early stage and keep it under review. Don't make an assumption that there is a lack of capacity, and think about proportionality in your evidence with regards to any capacity issues that may arise. And so I'm just going to open it now up for the question and answers. So hopefully, if you have any questions, you should be able to put them in the question and answers, hopefully. If that isn't working, then obviously the chat function is available as well. Okay, there doesn't seem like there's any questions. Obviously, if you have any questions that you want to raise afterwards, then feel free to email, and I will helpfully answer them if anything arises. And in which case, that's the end of the webinar. Thank you very much for listening.